So I want to welcome you to Legal Issues Facing Small Businesses. We have our very own SCORE Boston mentor, David Berman. He's definitely an expert in this area, so we're looking forward to all the information he has to share with us. This presentation is a part of what we're calling our Business Essential series. We do have a few more topics left for this spring going into summer. And if you want to take a look for those and sign up for those, we have cash flow, learning to sell better, pricing, and a great AI presentation coming up as well. We will start the series over again late summer, early fall. So keep a look for anything you missed. Some of these are on record if you did miss any of these and want to go back and look for them. But as we get going, I do want to explain to you what we do at SCORE and what we offer at SCORE to make sure you're taking full advantage of everything. Our goal is to share information with you about small businesses. We do that in several different ways. Our score.org website, lots of, there's podcasts, blogs, articles, templates you can download, previously recorded webinars you can watch, lots of great information. We also share information through our workshops and webinars. We advertise those through social media. They come out through our newsletter, and they are also listed on our website. I think the most important thing that SCORE does, however, will be the mentoring. And our mentors are volunteers, every last one of them. And they come to SCORE with a variety of skill sets and experiences that they've learned from so that they can share that with you. We work with folks that are trying to decide if small business is right for them. They're in that planning phase. They're in business, they're growing their business, or they're getting ready to exit their business or sell their business. So we work with everyone. If you have a question related to small business, we're there for you. A beginning session is going to be probably in the 45-minute range, plus or minus, depending on how many questions you have right up for that first meeting. But they're going to want to learn about you, what your goals are, so that they can help you come up with a plan so that you're successful. It's not uncommon that other mentors are brought in as co-mentors along that pathway as your needs change and progress. So it's just a wonderful experience if you've never had a mentor. Getting a mentor, very easy. There's multiple ways on the score.org website. I think probably the easiest is let us do the matching for you. You just put in your zip code. That'll match you to the chapter that's nearest you. And there's a little form that pops up. We just kind of want to know like what your business is and what your we can currently assist you. And that'll allow us to match you to a mentor to get things started. So format for today. We are using Q&A. It is easier. Chat can sometimes get a little crowded with other things, and certainly please feel free to use chat. But if you have a question for our presenter, please put it into Q&A, and we will try and get those answered for you and get everyone's questions covered. We are recording. Give me 24 to 48 hours. It will be posted on the score.org/Boston website. Look on the blue bar under the local workshops pull down, and you'll find previously recorded listed there. So I'm going to go ahead and pull down my share. And David, it's all yours.
Before I start, Teresa, there are a couple of people who said they had audio problems. I don't know whether that's something at our end or their end.
I'm going
You
to
see
guess
see the
yeah,
chat?
I do see that. I'm going to say it's on their end because I can hear you and you can hear me. So, yeah.
Okay. I just wanted to make sure it wasn't us. Thanks, Teresa. Thank you all for participating. We have a good crowd today. A lot to cover. I'll cover it probably not as in depth as is possible because you'd be here for the next 3 hours. And in any event, I'm just sort of giving you guidelines to think about. And, if we need more detail, you can ask questions. You can schedule a session with us. And in some cases, you should reach out to your own legal, accounting, and other professionals. That being said, let's start. The first thing I'd like to cover is licensing. Obviously, certain professions are licensed by the state. For instance, if you're going to be a doctor, you need to have a license, or a lawyer. Electricians get licensed, accountants and the like. So, if you're in one of those professions, you will need to have a licensed practice from the state. That's the obvious thing, but there are lots of other licenses that may be required that you don't think about. For example, if you're doing construction, you need a permit from the city. And it may be not just for the building, but in my case, I live in a building that's old, so they call it a historic building, and we can't even change the windows without getting appropriate approval from the local authorities. Um, you also have local zoning requirements, so that you need to check to see what you're doing if you're conducting a business or building a building, whether it fits within the zoning. If you were going to do, for instance, a pet store, you need to check to make sure that that is a permitted use and that you're not going to be subject to the local authorities saying you can't operate out of this location with that use. Um, in addition, if you're doing, for instance, a restaurant or a food business, the health department will want to come in and approve the location and the setup to make sure that it's not going to present an unreasonable health risk. If you're running a daycare or something like that, the authorities are going to come in and check and make sure that you're approved and licensed. So, depending upon the nature of your business, you may need some licensing, you may need some approvals. Um, I know I had a client who was trying to store something in a storage unit, and the fire department said that they couldn't store it there because it was a hazardous material that could cause harm. So you need to look at your business and look at the city and state regulations and see if it's something that you need approvals for. The next big topic is most small businesses that I deal with that aren't operating out of their home are operating out of a leased location. And there are various issues with the leases. I think the first thing I always tell people is to pick a good location. Forget about what the lease says, pick a good location. If you're uh, relying on walk-in business and there's no parking around, that could impact your business. If you're opening a pet store and there's another pet store down the street, that may not be a good location for you. So those are more business than legal issues, but location is very important in selecting a site. Now, you can enter into a lease for a term, which would be they're giving you a lease for 1 year, they're giving you a lease for 3 years, 5 years, whatever it may be, as opposed to a tenancy at will. A tenancy at will would be a situation in which either you or the landlord could terminate the tenancy on basically 1 month's notice. So if on February 15th you wanted to terminate, you could tell the landlord that the tenancy was ending on March 31st. For someone starting in business, that's not bad. Just like having a shorter term lease may not be bad because you'll have the opportunity to see if it works and not have the long-term financial obligations. At the same time, if your business takes off, you don't want to be in a position where in 30 days the landlord could say, I want you out because I found someone who's going to pay more rent than you, or I want you out because I don't like the way you park your car or whatever it may be. There doesn't have to be a reason for it. They can just terminate in 30 days notice. Similarly with a term, um, you don't want to establish a location, have a clientele that comes to that location, and then have the landlord in 1 year say, your term's up and I don't want to release to you. One thing that we often talk about for new businesses, if possible, is to get a short term at the outset, but build into the lease that you, the tenant, have the right to extend the lease at various times. So let's say you enter into a 2-year lease. Before the end of the 2 years, you can say to the landlord, I want to renew for another 2 years. And as long as you're not in default of the lease, the landlord will let you renew. There may be an increase in the rent to reflect current market situations, but that's one way to sort of protect yourself up front if you're not sure about the business. Do a short term, and then if it works, you can extend the lease. Um, you'll often hear the term triple net leases. What that really means is that in addition to your monthly rent, whatever it may be, you're going to pay your share of the landlord's insurance and taxes and common area maintenance charges. So, for example, if you opened in a mall, uh, the landlord has expenses to maintain the mall, clean the mall, so on and so forth. It has taxes it has to pay, and it has insurance that it maintains. And in a triple net lease, you would pay a share of that. And the share is usually based upon the square footage of your premises compared to the square footage of the entire building. So let's take you out of the mall example. If you're in a space and there are 5 tenants and you occupy 10% of the building and the other four occupy 90%, you'd pay 10% of the real estate charges, insurance, and maintenance charges for the building. Now, maintenance charges don't include, like, if it needs a new roof or anything that would be a capital improvement. Maintenance is more like snow plowing the parking lot in the winter, cleaning the parking lot, if they clean the windows, or if they have a service that comes in and empties your garbage at night, that type of thing. Um, so another way that we sometimes counsel people on this is to try to, if the landlord wants to uh, put some of those expenses on you, is to say to the landlord, I'll pay my share of expenses if they go up from where they are the day I come on. So if you can negotiate this, let's say the landlord's paying $1,000 in taxes on the day you enter, you'd say, I'll pay 10% of any increase over the $1,000. You need to have some leverage to get the landlord to agree to that, as opposed to 10% of all taxes. But it's always worth a try to say, listen, you've got these taxes whether I'm here or not. When I come in, I'll pay you if they go up. And you can do the same thing with insurance and with uh, common area expenses. But as I said, landlord may not be receptive to that, but it's worth a try. Remember, if you don't ask for something, you're not going to get it. The landlord's not going to voluntarily give it to you. Once you've located a premises, the question is, what work's going to need to be done in the premises to get it ready for your use? And then who's going to pay for that work? Uh, are you going to have to put up walls to create separate rooms? Do you need to create new bathrooms? Uh, is a new floor needed? What is actually needed for you to open up your business in a satisfactory manner at that location? And, major things we try to get the landlord to pay for. Like, if you need a new bathroom, that bathroom's going to stay there long after you're gone. It's an improvement to the building. Try to get the landlord to pay for it. I will say that, to the extent that the landlord agrees to pay for certain construction, you're likely to see that all or a part of that increases your rent. So if you went in and the landlord said, I'll do the construction, he'll say, I'll give you the space for $1 a foot. And then you say, I haven't got the money to front the construction. The landlord says, I'll pay for the construction. You may be paying $1.25 a foot rather than $1, because he wants to recoup some of that from you. But knowing what has to be done to open up and who's going to pay for it and who's going to ultimately be responsible for it is something else you need to consider in your lease. Some leases have use limitations, so that the landlord may not be able, if the landlord has a CVS in its strip mall or in its mall or in its location, they may be prohibited from letting you opening a competing CVS. And it may not just be drugstore versus drugstore. It may be that you're opening a food store where you're going to sell groceries, and CVS sells some groceries, not a lot, and maybe there's a restriction there. So you need to understand, and the landlord should tell you what use limitations there are. But you could also ask the landlord to include in your lease that he won't lease to anybody else that does the same business you do. Um, for instance, if you're a grocery store, you could say to the landlord, I don't want you to lease to another grocery store. And sometimes these use limitations just don't apply to where you are. I've seen them come into play where you say you won't lease to a grocery store on any property you own within 2 miles of this property. So, it's not just next door to you, it's within the region where you would attract customers from. Um, we talked about options to extend, options to purchase, a right of first refusal. You know, if you really love the space and the landlord wants to sell it, you may want to be first in line to buy it. So you can negotiate in your lease a right of first refusal if the landlord goes to sell it, that he has to come to you and offer it to you first. Or you could have the right at the end of your lease term to buy it for a set price. For most businesses starting out, this is not a crucial point, whether it's in there or not. But if you have a terrific location, and I had one client who had a restaurant, loved the location. The landlord was an older person, and so they signed a 10-year lease with the agreement that at the end of the 10 years, my client could buy the property for this price. And so that's something you can consider and do. Uh, Another issue that you need to be concerned with is assignment limitations. So, and what that means is your ability to transfer the lease. If you start a business and the business is not successful and you want to get out, either you shut down and you're going to have to owe the landlord the rest of the rent, or you find somebody who wants to take over the space and take on the lease. Many of your leases will say that you cannot transfer the lease to a third party without the landlord's consent. And so that may limit your options. And for the landlord to consent, oftentimes it requires the new person to guarantee the lease. It may say, I consent to the transfer, but you're going to pay me a fee for the transfer. You're going to increase the rent for the transfer. There are all sorts of conditions that the landlord can put on your ability to transfer if he has the right of refusal. So, that's something to be aware of. Uh, the other instance when it comes up is if you have a successful business and you go to sell the business and you want to, as part of the business sale, you want to transfer the lease, you need the landlord consent, and that could impair your ability to sell the business. So to negotiate these assignment provisions to say, you can assign it without the landlord's consent, and even if you put like 5 conditions in, as long as A, B, C, and D are met, that's better than just leaving it to the landlord's consent. Um, Defaults under the lease. One thing that uh, you want to try to build in is grace periods. So if your rent is due on the first day of the month and the check gets there the second day of the month, you don't want the landlord to be able to throw you out. Similarly, if you're obligated to do something and the landlord doesn't think you're doing it beyond paying the rent, you want the landlord to have to notify you that you're not in compliance with the lease because you haven't done this, and that you have a certain amount of time to get in compliance before he can terminate the lease. So make sure you add in grace periods for defaults to the extent you can. Oftentimes on a payment default, you can get 5 or 10 days, most likely 5 days, and make them 5 business days, not days, because Saturday and Sunday would count if they're not business days. So 5 business days. And for other non-payment defaults, you can get 15 or 30 days. And so make sure you ask for that so that if you have one little hiccup, the landlord can't throw you out. If notwithstanding that, the landlord um, defaults you and terminates your lease, the question is, what are the landlord's rights? Presumably, the landlord will have the right to collect rent as it becomes due for the rest of the lease term. A lot of leases provide that the landlord can accelerate the time for payment of the rent. So, for example, let's assume you have a 3-year lease and in the 15th month, you default and the landlord says, all right, your lease is over. So you still have another 21 months of rent to pay. And, at best, you want the landlord to say, pay me each month. But what the landlords do in some of the leases, and you want to avoid this, is they say all 21 months are due now at the end of the 15th month. So that really causes a cash problem. Obviously, adding to cash problems if your business is in default, but you would not want the landlord to be able to accelerate the rent. Your obligation would be to pay the rent each month when it becomes due. And in that regard, you want to make sure that the lease has a provision that obligates the landlord to try to mitigate the damages, meaning it has to go out and in good faith, try to find a new tenant. So the landlord, you don't want the landlord to sit back and say, all right, I have you on the hook for the next 15 months or 21 months, whatever it is, and I'm just going to sit here and collect from you every month. You want the landlord to go out and find someone to replace you. And that replacement could be at the same rent, in which case, presumably, you have no further obligation. It could be at a higher rent, in which case you won't have any further obligation because the landlord's doing better than he did with you. Or it could be at a lesser rent, in which case the difference between what the new tenant's paying and what you were obligated to pay, that would be the landlord's damages. So make sure that the landlord has an obligation to go out and find a new tenant. He may not be able to, but at least you want the obligation on him to do so. Um, a lot of leases require the tenant to sign a subordination or non-disturbance agreement. This is common. Don't be afraid of it. What it is an agreement between you and the landlord's mortgage holder that says that if the mortgage is in default, your lease is subordinate, and the landlord, the mortgagee by foreclosing, can extinguish your lease. But the benefit of it is the mortgagee also says that if you're not in default, I'm going to let you stay in the lease premises even after my foreclosure for the rest of your term on the same terms. So on the one hand, you're agreeing that the mortgage can foreclose and quote, extinguish your rights as tenant. On the other hand, the mortgagee is agreeing that as long as you're not in default, I'm going to let you continue to occupy and use the premises for the rest of the time. So there is a benefit to you there. The last thing I'll bring up on leases is force majeure, and I bring this only up because of COVID, because during COVID, we got lots of calls saying, you know, I can't go to the office, the government won't let me, or, I have a business where I give massages or personal contact and I can't do it. And they wanted to get out of their lease. And a force majeure clause means something has occurred that prevents the parties from performing under the lease. Um, Before COVID, force majeure clause were like things like war or government actions or fires or things like that. Since COVID, we've been trying to build in things like epidemics and other actions that took place during COVID, so that during that time period, you don't have to pay your rent and don't have to operate. Um, so before we go on next, are there any questions, Teresa, at this point?
Yes, we do have some questions. On the topic of licenses, how do you determine if your particular business needs a state or municipal license? For example, somebody on the call is selling loose leaf online out of their home in the Boston area. Do they need other licenses? How do they find that
Yes.
out?
Yeah, all right. I guess there are several ways to find that out. First of all, if you're operating a business from your home, you have to make sure that the zoning laws permit that. Um, and I will say this, many of our clients operate out of their homes and, you know, they don't uh, pay attention to the zoning laws, and 99% of the time, there's no issue. Where I've seen an issue operating out of your home is I had a client who was giving swimming lessons at his house, and people would come group lessons, and the whole street would be backed up with cars and cause traffic issues, and that's when the complaint went to the to the town and said, can he do this? So if you're just operating online out of your home, there shouldn't be an issue. But if you're doing something out of your home where there's going to be traffic or noise or something like that, you may want to check the zoning to make sure that it's permissible. In terms of licensing, um, the the easiest thing to do would be to uh, check, just do a Google search, Commonwealth of Massachusetts, licenses required for business, and see if your business pops up. Municipality wise, you could do the same search, or uh, you could go to the town hall and talk to somebody and see if there are any licensing requirements. As I said, I think that in general, if you're selling items from your house, if you're not, for instance, if you were selling a hazardous material from your house, there may be some issues with you doing that and storing the material at your house. But if you're selling pens from your house, unlikely anybody's going to require a license. So you have to think about the nature of the business. Is it something that's hazardous, that impacts health, uh, that impacts fire standards? And so on and so forth. But I would first Google it, and then if I didn't find anything, I would, ask the town. You can go to the town and ask them for, licensing bylaws. You want to see what the licensing requirements are, and they'll have bylaws. You probably can get them online as well. So my theory is always to try to check online, because once you go to the town and say, can I see your licensing materials? When they'll say, what kind of business? I mean, now you're on their radar. So, not that I wouldn't do that, but I would try to find out online first what businesses need to be licensed in the town or in the state. And another thing people also forget about, and this is not from your home, is if you put signage out, you need the license for the signs. Like, you can't, if you go to a strip mall and you see the big sign with all the names, they had to get approval from the city for that sign. So if you're hanging a sign out, make sure you get appropriate approvals as well.
Okay, some leasing questions. How is the legality of a commercial tenant differ compared to a residential tenant?
A residential tenant has more rights in terms of uh, obligations of the landlord, rights to notice and cure. It's just more rights for a residential tenant. Some of the provisions will be the same in terms of, uh, a term versus a tenancy at will, uh, in terms of what you can use the premises for, in terms of your ability to transfer the lease and defaults and remedies. There won't be generally in a residential any sharing of insurance taxes or maintenance costs. There really won't be any landlord's construction obligations usually. Um, so, there are lots of provisions that wouldn't apply in a residential lease, but also by law, the residents have some additional rights. We're talking about heat and uh, so on and so forth, that you can force the landlord to provide you.
Okay. I have two more lease questions, so we want to make sure we can have time to move on. So, um, what is the benefit of a long-term, like a 10-year lease versus a short term for the parties involved? Is one more common than another?
Um, I think that the answer depends. If you're a startup business, you would probably want a shorter term lease. And there are things as 10-year leases. What I often see is a 3-year lease with options to extend. So it will be 3 years and you can extend 3 times for 3 more years, or 5 years with two options to extend to 15 years. And the options to extend will, provide for an increased rent during the period. Um, if you have a 10-year lease, your rent's going to be locked in by what you originally negotiate. Now, that doesn't mean it won't increase, because the landlord could say for the first 3 years, you'll pay $1. For the second 3 years, you'll pay $2. And for the last 4 years, you'll pay $3. But that would be in the lease, and that couldn't change. As opposed to, if you do an option to extend, the rent will probably be sort of what the market is at the time, unless you can, you can try to negotiate with the landlord that, I've had leases where you had an option to extend and you said up front that the rent will increase by 2% a year if I exercise the option. So you can do that up front as well. But for a startup business, you know, I like a shorter term with options to extend. But there are business, like I'm sure like Vertex down in the Seaport area of Boston doesn't have a 3 year or 5 year lease. It probably has a 10, 15, or 20 year lease. And they want the knowledge that they can be there for a long time, whereas a new business may want the knowledge that they don't have that kind of long-term obligation.
Are revenue sharing agreements treated as leases?
Revenue sharing agreements, um, let me put that in terms of a lease, because there are revenue sharing agreements of all sorts. Many leases, commercial leases, will say that in addition to your base rent, you'll pay the landlord a percentage rent. So that, let's say you're paying the landlord $100 a year. I'm just making up silly numbers. You're paying the landlord $100 a year, and the landlord says, and I want percentage rent of, I want 1% of all of your sales as additional rent. Well, the 1% shouldn't kick in until the $100 is met. Let's use 10% because it's easier math in my head. So if you're paying $100 and the landlord was 10%, you shouldn't get 10% until your sales are over $1,000, because the 10% of $1,000 is $100. That's what your rent is. He shouldn't get his 10% on the first $1,000 of sales. It should only kick in for amounts in excess of $1,000. But there are percentage rent clauses that landlords will include in the lease to give them a greater return if your business is successful, that they share in the success. There are also the possibility in some cases to negotiate that your rent will be a percentage rent from the outset, or it'll be a percentage rent until a date certain. So the landlord says, I know you're just starting up, give me 10% of your sales for the first year, and then after that, you're going to pay me $100 a month. Or, if you have negotiating power and the landlord really wants to let the space, and you're starting up, you could say, listen, I want you to give me 3 months free rent, 6 months free rent, a year's free rent, whatever free rent you can negotiate. It depends on the marketplace whether you can do that. I throw out years ago when there was a real estate crisis in Houston, all the landlords were offering their office tenants 1 year's free rent. So guess what happened? I signed up with landlord one for 1 year's free rent. At the end of year one, I left and went to landlord two, who gave me 1 year's free rent. So I had several years of free rent. But so you're not likely to get a lot of free rent, but as a startup, you may be able to negotiate that you got 3 months to pay, not pay rent, or if you have some work to do, the lease starts today, but you don't have to start paying rent until you open for business. So if you need 3 months to get your premises ready for business, that he won't charge you rent for those 3 months, and your rent will start when you open for business. So the percentage rent uh, is possible in some leases for, depending upon the nature of the business and um, what the landlord wants for a return.
Okay, let's go ahead and move to the next topic.
Okay. Now we're going to talk about employment agreements, uh, both from the point of view of the employer and the employee. Again, we talked about tenancy at will, which meant that the landlord could terminate you in 30 days notice. An employment agreement at will, the landlord can terminate you tomorrow, with or without cause. So, we just read in today's paper that local PBS station, GBH, is laying off X% of its workforce. Those are probably all at-will employees, and they just needed to cut back expenses, and so they fired them. And that's an at-will employee. You have no guarantee that when you wake up tomorrow, you'll still be employed. Um, Employment contracts can also be for a term. For instance, if I'm General Motors and I'm hiring a new chief executive officer, he's not going to want to be an at-will employee. He'll get a contract for 3 or 5 years, and the contract will lay out the terms of his salary and bonus and so on and so forth. Think of it, an athlete. The Red Sox, who overpay for everybody, they sign people to a 7-year contract. That's a term contract, and if they release or terminate the player in year 3, they still have to pay the rest of the term. Um, so depending upon whether you're the employer or the employee, you may or may not want a term. A lot of businesses also like to engage people as independent contractors rather than employees. And the reason for that is, if you have an employee, you're going to have withholding taxes, and you're going to have to pay the employer's share of withholding in Massachusetts, parental leave and to Social Security and so on and so forth, so that your actual cost of employee isn't just the gross weekly salary you're paying him or her, it's also all these added uh, taxes, so to speak. Independent contractor is just that. Think of the plumber that you call your house and say, I got a clogged toilet. He comes, he gives you $150 bill, you pay the $150, and he has to pay his taxes out of that. You don't have to pay anything other than the $150. Um, there are strict tests on who can be an independent contractor. The independent contractor can't be subject to your control. In other words, you can't say to the independent contractor, you have to come to my office and work here from 9 to 5, 5 days a week, and take lunch for 20 minutes and do this and do that. An independent contractor is somebody who's hired for a specific job, like the plumber. You say to the plumber, I need you to come unclog my toilet. He comes when he damn well pleases, right? He's not going to tell you, I'm going to be there tomorrow at 2. I mean, if he's a good plumber, he'll give you an idea, but he comes as he desires. He does the repair as he desires. He's not following your directions on, unscrew this, plug in this, or whatever. He has the professional expertise so that he controls his time when he does it, and he controls how he does it. You can't direct him. And similarly, he's in a business that you're not. So it's if you're running um, a business where you're advising people on how to get into colleges, and you hire me to take some of the overflow because you have too many, and that's my line of business too. The government may say that I'm not an independent contractor, I'm an employee because I'm in the same line of business doing the same work, as opposed to the plumber who comes in and you're a consultant to the plumber's his own business. So the independent consultant should have its own line of business distinct from yours, and keep control over it. If you hire somebody as an independent contractor and it turns out that government views him as an employee, you'll have to pay some of these, taxes and maybe some penalties as well. The thing I would say as a practical matter, a lot of our clients try to hire people as independent contractors because they don't want to have them as an employee. They don't want to pay those extras, and they run a little bit of a risk. But for a startup business, that's the way that they think that they can do it best. Um, all right. Other things that you may want to think about in your employment agreement: compensation and benefits. Um, are you being paid a salary? Are you being paid an hourly basis? Are you entitled to, vacation pay, health benefits, disability benefits? What other benefits uh, are you entitled to? Is there a 401k plan? Do you contribute? Does the company contribute? So on and so forth. Those should be laid out, as well as specifically what your job is. what your duties are. Um, so that there's no dispute that if you're asked to do accounting functions or bookkeeping functions, that they can't tell you, I want you to go downstairs now and work on sorting the inventory. I mean, as a practical matter, in a small business, people do many jobs, but you should specify what you're being hired for and what the job is. Um, a lot of employers try to include a non-compete clause. Non-compete clauses are frowned upon in most jurisdictions. Massachusetts is a whole law in terms of what you have to do if you want to make them enforceable. Non-compete clause may have more force and effect if it's a senior executive. For instance, if I'm a receptionist and I'm in a law firm and I'm told if I leave, I can't compete, I can't work in another law firm, that's probably not going to be enforceable. But if I'm the chief operating officer of a company, a high executive position, they may try to get me not to compete. But the law favors letting people earn a living. And so you're going to have to show that you complied with the appropriate law and that this is a reasonable protection for your business and reasonable to the employee. Like California doesn't enforce any non-compete, so it's a state by state thing. There's been thoughts at the Federal Trade Commission to ban all non-competes. So that's an area worth watching. Uh, Non-solicitation, however, can be enforced. And what non-solicitation would be is that you can go out and compete with me, but I don't want you taking my employees with you. I don't want you taking my customers with you. Um, so go compete, go get your own business, but don't steal from me is basically what that is. That usually has a time period on it that you can't take my employees for a year, you can't take my customers for a year, and you can limit the non-solicitation to customers who you worked with. If so, in other words, if you worked with Teresa's company and you won't solicit Teresa's company for a year after you leave my employ, but you could go after any other customer that you didn't work with. So non-solicitation, while once again is state by state, that is a little bit more enforceable. And remember, it's non-solicitation. It's that you will not go out and solicit my employees. If you leave and Teresa says, I want to work with David. I haven't called her. I haven't asked her to come work for me. She just says, I'm quitting and go for me. So I didn't solicit her. She came of her own volition. That gets into all sorts of legal messes, but just remember, it's that you won't solicit, not that, if when I was in the law firm, when somebody left, the client would say, I like working with so-and-so. So-and-so couldn't solicit, but they said, I'm leaving you and I'm going to work for him. That wasn't them soliciting. The client just went that way. Non-disclosure is important. You don't want any of your confidential business information spread across the world. So your employees should be subject to a non-disclosure agreement, which they agree to keep all of your trade secrets and proprietary material confidential, use them only for purposes of your business, not to share them with anybody else, not to publish them, and keep all your important information confidential. Uh, Many companies have an employee handbook. That's what company policies are. Those handbooks can deal with things such as, what you have to wear to work, how many days you have to come to the office, what your vacation days is, what your sick pays are. There are usually harassment policies in there and so on and so forth. Um, and so that's something else that a lot of companies do is develop policies which are part of the employment contract or part of your agreement. You have a employee handbook and you get the employee to sign on saying, I've read these and agree to comply with them. And the policies will differ from company to company. I just want to point out that an employee, if he uh, does something during the scope of his employment, the company is going to be responsible. It's called vicarious liability. that they're really an agent for the company. An independent contractor isn't an agent. An independent contractor can't go out and sign a contract to purchase 62 pens a month from a pen company. That won't bind you. But, if your office manager did that, that would bind the company presumably. So be careful in terms of, what authority you give people and watch what they do. Now, why don't we ask questions here, Teresa, and then I'll move on to other contracts.
Yeah, for a startup that has volunteers, do you need a contract?
Well, first of all, I would have the volunteer agree to confidentiality. I would agree to have the volunteer comply with the company policies. And do you need a contract? Not necessarily, but it would be nice to have something in writing that says you are a volunteer and you're not going to be paid. And this is what you're going to do. Is it absolutely necessary? No, it's not absolutely necessary to have any contract with anybody. That could be an at-will employee. You walk in and the person selling perfumes at Saks doesn't have a contract. She's just an employee. But, I think it's nice to have a writing with anybody saying, thank you for volunteering your services. I understand you're not going to be entitled to any compensation or benefits, and you're going to abide by our confidentiality and company policies. So is it necessary? No, but I think it's good practice if you can.
Does the non-solicitation apply to customers as well?
Um, the answer is it can, yes, that you cannot solicit the company's customers. Um, And, um, that's a little bit different than not soliciting the employees because once again, you're entitled to go earn a living. But, if many contracts do provide that it applies to the customers as well. Doesn't apply that the customers can't leave and work with you because they can't bind the customers in your employment contract. All they can do is bind you to say, I won't go out and tell XYZ company they should leave you and come work with me. Um, Okay,
Yep, let's move to the other.
okay. Um, so other things, if you're just doing a contract that's not an employment contract, what do you want in the contract? You want to specify what the services are in detail. So, and what they're not are. So for example, if you're being hired as a consultant, uh, what are your duties? Is your duty to uh, you don't want to say you're being hired as a consultant to provide consulting services because then you get into a dispute. You think you're hired to consult them on how to set up their IT systems, and they think that that includes doing also X, Y, and Z. So it's important that you specify what your services are, what's included, what's not included, because you're going to get paid based on what you quoted them for doing certain services, and you don't want them to build other services in that you never intended uh, in there. Likewise, in terms of services you want to put in, what the person you're contracting with is obligated to do. If you're a consultant and they don't make their records available to you, they don't make their personnel available to you, you can't do your job. So you should specify, this is what I'm going to do, and in order to do it, it's important that you guys do this, provide me with secretarial assistance, provide me with, meetings with your key employees once a week, provide me with all your records on this subject, whatever else it may be. Um, then the contract should also deal with payment terms. Are they giving you a deposit up front? Are they paying you weekly against invoices, monthly against invoices? Are they paying you hourly? Are they paying you a fixed fee? And how does that all work? You need to set out upfront what the amount of the payment is, whether it be hourly or fixed fee, and how it's going to be paid. Like if I'm building a house, I usually give my contractor a deposit of 50%. And then when he gets to a certain stage, I give him another 10 and another 10. And, so it's staged payments. Um, if you're providing a consulting service, you could uh, do it that way, or you could just say, I'm going to give you monthly invoices on an hourly basis and you'll pay them. Also, what expenses are included. If I'm doing consulting services for a client that has offices in Boston and in Ohio, and I have to go to Ohio, is the company paying for my airfare, my hotel, my food, so on and so forth. So, excuse me, you need to include what your payment terms are and how it's paid. And you're going to want to include that if it's not paid, that you are entitled to collect interest in the overdue amounts and also to be reimbursed for any legal fees you incur in going to enforce it. Um, Exclusivity. Most contractors are going to be non-exclusive. So the plumber, for example, that comes to my house, he's not just working for me. He can work as many jobs as he wants. But there may be some circumstances in which you're an exclusive provider. For example, if I'm a manufacturer and I have to buy certain inventory, I may want an exclusive arrangement where my supplier sells that inventory only to me. And obviously I'll pay for that, but you need to uh, lay out that either you're exclusive, which means you won't work for others, or as most contractors do, non-exclusive, you can take on whatever jobs you want. Um, Question is, what warranties are you giving on your work? If you're manufacturing an item, there are implied warranties of merchantability and fitness, but are you giving any other warranties, express warranties that warrant this for a year? Are you warranting everything? Are you warranting, the workmanship? Are you warranting the materials? What are you warranting? If you're a consultant, you probably don't want to give any warranties because you're saying, I'm going to give you my best advice, but I'm not going to guarantee you a result. I can't guarantee you a result. It's like I had one client who was an educational consultant, and after she consulted this high school student, parents came in afterwards and said, my son didn't get into Harvard. And she said, well, I never guaranteed you he'd get into Harvard. I told you I'd help him with his applications. But, so consultants, you probably don't want to give any warranties, other than the fact you do your best job. Um, yeah, but if you're producing a product, the question is what warranties are you giving and how long do they last and what are the customers' recourse if the product fails? Um, Indemnification, um, if you're a consultant in particular, you will want anything that arises from your work, you don't want to be in the middle of a lawsuit. So if you said to somebody, my best advice is that you should go out and uh, hire 5 new people to cover your tasks. And they hire the 5 new people, and it turns out that they really only needed 2 people. You don't want them to say, I'm suing you. Uh, or to take my example of the educational consultant, I'm suing you because my kid didn't get into Harvard. You want anything you do, if there's any lawsuit, you want the person you're contracting with to be responsible for paying the cost of defending that suit and paying any damages that come out of that suit. The exceptions to that would be if you intentionally did something wrong, like for instance, you uh, walked into an office and you didn't like your boss, the person you're reporting to, and you took a hammer to his head, that wouldn't be uh, um, indemnifiable. And similarly, if you're grossly negligent, which means not that you made a mistake, but that the rest of the world says uh, you should inoculate your child for this, and you say you shouldn't inoculate your child at all, and so it's grossly negligent, against norms of the industry. But in general, you don't want to give advice to somebody and then be the subject of a suit because the advice wasn't acted upon or was acted upon and didn't work out. Uh, Also, in your contract, if you can, you want to limit liability. So let's assume that you've agreed to provide a part to a company that's making a machine. Um, if that part fails, let's say it was for an airline and the plane uh, uh, crash because the part failed, you could be subject to lots of damages and liability above and beyond your insurance. So sometimes we like to put in that if we breach the contract, all you can do is to recover from us the amount you paid us. Now, in the airline example, that probably is not going to work. But if you're a consultant and for some reason you're found to be responsible, you say basically, I'll give you your money back. That's all you get. You can't, the fact that you claim that you lost $10 million of profits, not my problem. I'll give you back your money. So you like to put in a limitation of liability clause that tries to limit your downside. Once again, all of these are not always in contracts because it takes two to tango, as they say. But if you're presenting your contract, these are things you'd want to at least start out with. And then dispute resolution. If you have a fight, how are you going to resolve it? Are you going to First of all, obviously, you're going to try to work it out amongst yourselves, but if you can't work it out, do you go to mediation? Mediation will be a third party unrelated to either of you who hears both sides of the story and tries to come to a solution, a mutually agreeable solution. Mediator suggestions are not binding. A mediator could say, instead of paying $1, I think you should pay $1.50, and instead of asking for $2, I think you should take $1.50, and you both can say thanks, but no thanks. So then the question is, do you go to arbitration, which is binding, which is once again a third party who hears both sides of the case and makes a decision that's binding, or do you go through the court system? So these are decisions to make. Obviously, mediation is less expensive than arbitration, which is less expensive than the courts. And in terms of timeliness, mediation usually can happen more quickly than courts, as does arbitration. Teresa, anything on this before we
Yep.
move on?
How often is a non-disclosure been challenged or enforced? Once company data has been shared, isn't it hard to determine what, if anything, is shared, leaving most of it to be an honor system?
Well, where this comes up mostly is when an employee leaves you to goes to work for somebody else, and somebody else comes up with a similar product, right? So then you find all of a sudden that this trade secret that you had, let's say you had the recipe for the world's greatest brownies, and your chief brownie maker left and went to another bakery and used that same recipe. You find out in that way. A lot of it is the honor system, but there are ways you find out that information has been leaked. There's no surefire way other than keep your eyes and ears open. But there are exceptions to confidentiality. For example, if you get subpoenaed by a court, you have to listen to the court. And so even if you have confidential information, if the court tells you to produce it or testify to it, you have to, unless the company can prevent it somehow. If the information was public before you got it, like, that this company's brownie recipe was written up in a magazine, that's public information. It's not a secret anymore. So there are exceptions to that, but you're right. The only way to really figure it out is to keep your eyes and ears open and see, what is happening with your information.
Okay, we can go ahead and move forward.
Okay. All right. Intellectual property. People like to protect their intellectual property. The first area is trademarks. Trademarks can consist of a name. It can, like, the Golden Arch, that's McDonald's. It can consist of a logo, like the swoosh of Nike. And those are protected because they have taken the appropriate steps with the United States Patent and Trademark Office to protect them. You can protect trademarks locally in your state, but that really doesn't help a lot. If imagine Nike in Oregon protected the swoosh only in Oregon. That's not what it wants. It wants to protect it nationally. And you can only protect it nationally. You can't protect it overseas. If you want to protect it overseas, you have to go to those countries and protect it under their trademark laws. Um, One thing to do if you have a name or a mark that you want to protect is you can go to the uspto.gov, which is a website, and that's the Patent and Trademark Office, and you can search, type in the name, and search to see if anybody else has that protected. Um, I've had clients who went in and found that it was protected, but it was somebody who wasn't using it anymore. So they reached out to the somebody, and the somebody either gave it up, or for a few bucks, they said, okay, I'll give it up and you can use it. But you need to, before you start using a mark or name, you should check in the trademark office to see if it's already used and how it's already used. Because, McDonald's can be used for the hamburger chain, but it could also be used for, McDonald's grocery store or McDonald's hardware store. And, that's really not going to be an infringement of the McDonald's hamburger chain trademark. Um, Patents and copyrights, the patents, is a very all of these areas are specialized, and you probably should get legal help at patents. You can file a provisional patent, which, we all see patent pending. That means it hasn't been acted upon, but it's provisionally out there, and nobody should be able to use it. I think it's a 1 year period you're protected for patent pending, and then they act on the utility patent. Um, or design patent or whatever. Copyrights would be for things you write, like an author writes a book. There's a separate copyright office that you can go to and get copyright protection for a long period of time. I think you have to get it within a certain number of days after it first is published. But if you have something that is published, you go protect in copyright. As I said, these are specialized areas in which you really need expert help to get it. There are also things that aren't trademarked and aren't patent and copyrighted, but which are just trade secrets, like that recipe for the brownies. That's a trade secret. You don't have a patent or copyright for it, uh, or a trademark. It's a secret that your business has. Your secret sauce. That's a trade secret too that should be protected. And so, other than going and making the filings with the Patent and Trademark Office or the Copyright Office, one thing that we always recommend is that whoever's working with you signs that confidentiality agreement, that they agree not to disclose your trade secrets. Um, you know, I'd say most people abide by their contractual provisions. That's not to say all do. Most people do. And so if you highlight that to them in their contract, um, you should have protection. In that regard, just to briefly talk about non-disclosure agreements, if you're thinking of entering into a transaction with somebody and you're going to give them some intellectual property information, you should enter into a non-disclosure agreement before you give them anything, which will say basically that we're thinking of doing a deal with you. We're going to share with you some confidential information. You agree not to use it except to consider this deal. And if the deal goes through in connection with the deal, and if the deal doesn't go through, you'll return it to us and you agree you're not going to disclose it for 5 years or 7 years or whatever it may be. So a non-disclosure agreement is another important tool when we talk about contractual provisions in intellectual property. The last area, which I'll touch quickly since we're past 11 o'clock and I talked too much already, is insurance. Um, Businesses should consider personal injury and property damage insurance, especially if you're operating at a premises or if you're interacting with the public. Even online businesses tend to get this, but that protects you against if somebody's injured or you destroy some property. You're driving your car and you go through the window of the Apple store. So you'd have protection there for the property damage you caused, and if somebody came in your store and slipped and fell, you'd have personal injury protection. The insurance would protect you so that you don't have to come out of pocket for that. If you're selling a product, you need product liability insurance. Product liability insurance protects you if the product is faulty. So if you're selling food and the food you put out has salmonella in it, and even if you recall it, people have bought the food with salmonella, you want the insurance company to protect you from product liability for damages caused by the defectiveness of your product. Food is clearly something you would need it for, but really anything that you're uh, manufacturing and selling to the company. For instance, the airline example I gave you, that little widget, they'd have product liability insurance, which would cover any loss arising by the failure of the policy. Um, Business interruption insurance uh, is something else you want. If, for instance, there's a fire and you can't operate your business for a while, business interruption insurance will pay some of the losses that you incur because the business is closed. This was attempted to be used in COVID a lot, saying that it was business interruption, and the insurance companies balked at that, and a lot of them won, saying this isn't what business interruption was intended to cover. But business interruption insurance is good to have if, for some reason, you can't operate your business. Couple of other thoughts: keyman insurance policies. If you have a business and you have a few key employees, you may want to get insurance on them. There are several reasons to get insurance. Number one is perhaps they own a portion of the company and you want to buy back their portion upon their death. This gives a fund to buy back their stock. Their heirs get the money, you get the stock back, and it hasn't cost you anything out of pocket other than whatever the premiums were for the keyman insurance. Uh, Another reason to get keyman insurance is if I'm the chief of manufacturing and something happens to me, in addition to whatever you owe me, um, you may need to operate by finding somebody new or not finding somebody new and hiring somebody on a temporary basis. And you could use the insurance money to pay for any additional costs of running the business. Although keyman insurance is usually in fact used to pay out the decedent or his family. Um, and the last thing that I would say for small businesses is a lot of small business people get umbrella policies, which uh, like I'll give you an example. I have car insurance. Let's say it's 300,000 per accident, 500,000 in the aggregate. I have an umbrella policy of $1 million, so that if the costs exceed the amount of insurance that I have on my car insurance, the umbrella policy kicks in and picks up the excess for another $1 million. So, if you decide to have personal injury and property damage insurance for, $100,000 and $300,000, but you want to be more insured, you get an umbrella policy that picks up where that left off to cover excess. Teresa, I've gone 8
Yep.
minutes over. Any questions?
Yeah. What is the minimum must-have insurance necessary for a single member business consulting service company?
I would single business consulting company. I would have, one other thing that isn't listed here is professional liability insurance. For instance, if you're a lawyer, an accountant, or a psychologist or something, that you should have professional liability insurance, and that would be the biggest one for somebody rendering those types of services. Beyond that, a single member, it depends on what your business is. So, I'd say of the insurances, personal injury and property damage and product liability would be appropriate depending upon the nature of your business.
Are the concerns on selling food the same if you're selling a third-party food product? Like you're not the manufacturer of the food product.
Right. Well, the answer is that if the lawyer is going to sue on behalf of the client, they'll probably sue you as the seller as well as the manufacturer. Um, there may be agreements with the manufacturer. The manufacturer will indemnify you and defend and take over the defense of the claim. But I would I would have product liability insurance because let me give you an example. The manufacturer sells you X product, and the manufacturer says you have to store it in uh, cool conditions, and you store it and you sell it and people get sick from it, the manufacturer could say, that wasn't my fault. I told them to store it in cool conditions and they stored it at room temperature. So therefore, you could be in the middle of a suit there. And so therefore, I would, even if you're not uh, manufacturing the product, I'd think about getting that insurance because the manufacturer can always say, what I did was right. It was the person who handled it in between me and you that got it wrong.
Okay, I'm just typing an answer to somebody. It's because it's a question that we did not cover today. I'm going to give you my email address and you can reach out to me. We can set you up with a mentor. All right, let me send that. The labor laws. Oh, okay. Yeah, I had some back and forth on the volunteers working for a business. I think there was some issues with whether the business was a profit or a nonprofit.
Right,
Um,
right, right. I mean, sure, there are minimum wage laws, and it's like if a university puts students out as interns, in some cases they have to be paid under minimum wage law. In some cases, you can get away and not pay them. But that is true. I mean, I agree with whoever made that comment that there can be issues.
so perhaps the person that was asked that question might want to talk to a mentor more in depth on the topic.
Right.
Let's see, we had a question that I got missed. Ugh, that's why I don't like questions in chat. They're hard to lose track of. Yeah, can I'm gonna say, can you go? I'm gonna put my email into the chat. And just please go ahead and send that to me at outreach at scoreboston.org and we'll get you an answer. I don't know what the question was. It kind of got lost in all the chats. So please just send that to me and we'll get that out to the right mentor to get your question answered. Um, all right. Thanks, David. That's a lot of information. We know that there's more in depth that there could go into on some of these topics. Definitely reach out to us for a score mentor to go to talk to your business on these topics. And thanks, David, for giving all that information. And thanks everyone for joining us. And we hope to see you again on another presentation. Thanks, everyone.